Good morning, everyone, and welcome to Thursday Career Development Day. And today is September the 3rd. I just told everybody they need to start getting their Christmas list together. It's getting that time. So without further ado, I'm going to actually turn everything over to, I am recording this, and I'm going to turn everything over as host to Jared as soon as I find his name on here. And Jared is our speaker today. He's going to talk about estate planning. He is a CPA and an attorney, and that is all that I'm going to share. Jared, I'm going to turn this over to you, and I would like you to just share a little bit about you, who you are, before you get started.
Sure.
And I'm turning that over to you now.
Okay. I appreciate you asking me to participate today and speaking with everyone. Basically, my name is Jared Trubin. I'm an attorney with Owen and Trubin in Winchester. We're primarily estate planning firm, although we do a lot of other work too. Primarily tax planning, LLCs, corporations, estate planning, a lot of that type of planning. We don't really go to court. We're not litigators, although we do provide some assistance to litigators if they require that type of expertise. We cover clients pretty much throughout all of the Northern Shenandoah Valley, all the way over into Loudoun and Fairfax. We have clients all the way down the Shenandoah Valley, all the way down to Harrisonburg, some, so we've got quite a wide coverage as to where we cover. We do have some West Virginia clients as well. One of the other attorneys here is licensed in West Virginia and does some work there as well. There's 4 attorneys here in our firm, and we're all Trubins, one way or the other. And so Mr. Owen was the senior partner. He just recently retired last year. So it's now just the Trubins here. But we still are called Owen and Trubin because that's her name. So I'll just get started here with the presentation. Let me get my screen shared here.
But if you notice, she never keeps the puppies. She sells them all.
Okay, can everybody see the presentation now? All right, so when I was asked to present, they told me they wanted to kind of give kind of a basic background in estate planning. And so that's what this presentation is geared towards. It's not very in-depth, it's more of the basics. There's a lot more to this type of planning than what I'm covering. So certainly if you have questions, feel free to ask at the end, and I can give more detail if you want more detail. But we'll just start with the basics here. So let's see here. Why do people do estate planning? Well, there's a number of reasons why people do estate planning. These are kind of the 3 biggest reasons people will do it. To divide and distribute their estates. They're primarily interested in knowing where their estate's going to go when they pass away, how it's going to be divided. They also want to designate someone who's going to handle things after their death. Because sometimes clients may have certain family members who they don't want to have a part of handling their affairs, or maybe it's a friend or someone else who they feel is more capable of handling things, and they want to be able to designate that person. And then also people do estate planning to handle things while they're alive as well. Obviously you'll hear instances where people are very sick. They either have Alzheimer's or dementia, or they just simply have gotten old and it's hard for them to handle things on their own. And so they'd rather have either their children or a close family member or loved one help take care of things while they're still alive. And so that's why people will do estate planning generally. There's other reasons, but those are the biggies. The main documents that people use for estate planning are usually these three basic documents. There's other documents too, but these are the biggies. Your will, your last will and testament, a power of attorney, and that sometimes will go by a couple different names, but that's what I'm calling a power of attorney. And then something called an advanced medical directive, and that also goes by a couple different names as well. I'll get into that in a sec. But those are the main three. Your will, it's what you think of. It's the document that's going to say what happens to your stuff when you die. It has a lot of different provisions in it, some of which are what you would think of as typical boilerplate provisions, legalese, legal mumbo jumbo that only attorneys know what it means, that kind of stuff. But for the most part, it's going to say, well, what happens when you die? It's going to go to this person or that person, your spouse, your kids, charity, whoever. Some of the things you need to think about, though, when you do a will are your executor, for example. You have to name an executor. That's the person who's going to be in charge. Now, some states will call it a different title. Virginia calls it an executor. Some places will call it a personal representative. It's the same thing. You might see a term called an administrator. In Virginia, that's someone who is in charge of your estate when you don't have a will. That's also called intestacy. That person's called administrator. Functionally, they pretty much do the exact same job as an executor. So your will, you need to name an executor. And some of the things you need to think about are, well, how many executors are you going to have? There's no requirement that you have a certain number. You can have one, you can have 10. You can have any number. I would say as a practical matter, it probably isn't good to have probably more than 3 or 4 at most, because then it gets to be kind of unwieldy because you got so many people in charge, and it gets to be kind of a pain. You might see some attorneys recommend that you should only have one, because then you have one person who makes all final decisions. And I can understand the advantage of that. I tend to think there may be some detriment to that if it's a relatively close family, where, for example, maybe you only have 2 kids. So now you got to pick one of them to be the one in charge. Is that going to create some sort of strife with the other one who didn't get named because now they think mom or dad didn't love them as much? Things like that can happen. And so I tend to tell clients, if the kids get along and there's only like 2 or 3 kids, you can name them all. But now if there's other reasons why a child shouldn't be named, for example, then we can talk about that. Residency requirements, some people will ask, well, does your executor have to live in the state where you live in? In Virginia, no. That used to be the rule a long time ago, but nowadays you can live anywhere. The only hindrance to that is if you are an out-of-state resident, then you do have to post surety on a bond when you qualify as an executor. And essentially what that means is you have to put up additional money to act as security in case you were to skip town with all the money and blow the estate. And the beneficiaries have nothing. And so the court requires that you put up security to help ensure that doesn't happen. But other than that, you can live anywhere you want and serve as an executor. The financial considerations, again, that's partly of, thinking of who's going to be in charge. You want to make sure the person who is in charge is capable of doing that job. You tend to have some financial acumen. You have to know how to handle money fairly well. You have someone who doesn't get in any debt, it doesn't have creditor problems. That's usually, preferable. It's not required, but it's just something to consider. Other things you have to keep in mind when you're doing a will is if you've got a prior marriage situation, or if you've got a second marriage, stepchildren involved, property that's located out of the state. And then you can also have property that passes outside of your will. And what I mean by that is you can have certain property, life insurance is like a classic example, or retirement accounts, IRAs, 401ks, where you'll name a beneficiary. When you name a beneficiary, that beneficiary will receive that asset upon your death, regardless of what your will might say. So for example, if you say, I give this insurance policy to my children, but then your will says, I give everything in my estate to my spouse, your spouse is not going to get the insurance. Your children will get the insurance because they're named as the beneficiaries. And so you have to keep that in mind when you're doing a will, that if you have property that you had already named a beneficiary, that those coordinate with what your intent is. So that's just something to bear in mind with that. Powers of attorney. Now, a power of attorney is essentially a document where you have named someone, who I call your agent, as having power to do something. There's different kinds of powers of attorney, limited powers of attorney, or general powers of attorney, and they all have to do with how much power that agent has. General powers of attorney are fairly broad in that they give your agent a lot of authority over a lot of different things, a lot of power to do things. Limited powers of attorney are usually powers of attorney where they're limited to a certain specific thing. The ones I see most often are where you've authorized someone to sign a deed, or to sell a piece of property, or go to closing for someone because they're not located in the state, so it's logistically impossible or difficult for them to get there to closing. And so they authorize someone to sign the closing documents on their behalf. And so they execute what's called a limited power of attorney to authorize that agent to do all that, but it's limited exclusively to that purchase, let's say. Now, a general power of attorney is usually what's done in the estate planning context. And sometimes you'll see something called a springing power of attorney, or a durable power of attorney. A springing power of attorney is typically a power of attorney that comes into play, or that I should say the agent has the authority to act at a certain event. Usually it's the event where the person who created the power of attorney has become disabled, or some other triggering event for them. Usually it's disability. A durable power of attorney is where the power of attorney continues upon the person's disability, because you could have a power of attorney that terminates upon the person's disability or doesn't allow the agent to act. I don't really see powers of attorney that are not durable, just because the whole point is usually to give the person the ability to take action in a lot of different circumstances. I also don't see springing powers of attorney that often, although I have seen them. The reason being is there's a lot of times where you want the agent to be able to take action even if you're not disabled. So for example, you might be on vacation, although that might not be happening right now. You might be away, or you can't act for whatever reason, and the agent needs to do whatever it is they need to do. In that case, you're not disabled, but they need to take action. And so a lot of times I will prepare a power of attorney, for example, that's durable and general, so that it gives the agent as much power as an authority as possible, just to make it flexible. So who do you name as your agent? Usually it's, people will name their spouse, or their kids if they think they're mature enough to be able to do it. Sometimes if neither of those options is available, you might have a bank serve. Some banks will have a trust department that can serve that role. They may charge you a fee for it, but they'll serve that role. But you usually have to think about it. Some people will get concerned, well, does that agent have the ability to access my bank account? Usually yes. I mean, if you don't want them to access your bank account, that can be a power that you remove, although that really undercuts their ability. But usually people will get concerned, well, if they are able to access my bank account, you know, do I have to tell them, or, you know, I'm concerned about that. Usually my response to something like that is, if you're concerned that the agent is going to do something wrong, then just don't name them. Name someone else. The person who you're naming them because you trust them. They're what's called a fiduciary, so they have to act on your behalf. They have to act in your best interest. If they don't do that, then arguably they've committed a crime and they can be held responsible for that. But for the most part, you want to name someone who you think is going to do the job that you want them to do, and be honest about it. Another question comes up with families, particularly with kids, is do you have multiple agents or not? I have no problem with that, for the same reason with the executor. You know, sometimes you have people who have multiple kids. They're not close to one another. They're not necessarily close to mom or dad, but you know, they can do the job, and you don't want to necessarily hurt anyone's feelings, so you can have them both do it. That brings up the question of, do you want them both to agree to do things together, or do you want to allow either one of them to have authority? And that really depends on the situation. Some families may want that. Some families may not. There's pluses and minuses to both, but it's just something that you can consider. But there's nothing that says you can't have multiple agents. You can certainly have more than one. And again, like the executor, I wouldn't have more than like 2 or 3 perhaps, just because it gets to be a little bit too much. Specific powers to include, again, with a general power of attorney, I tend to make it very broad. I tell clients, it's pretty much anything you could sign your name to, your agent can sign your name. It's as broad as that. And we do that because we want to have the agent have as much flexibility to do something at a moment's notice in case you couldn't do it. And so that's why we make it as broad. Now, if you want to limit their ability to do certain things, you can certainly do that. And we, you know, we can certainly tweak the document to say whatever it is you want to say. But usually the general power of attorney is going to have a lot of ability for your agents to do a lot of different things. So you just need to bear that in mind when you're thinking about that document. An advanced medical directive is, it's a couple different things. What I'm calling an advanced medical directive, Virginia refers to that term. Some states will call it a living will. Some call it a healthcare proxy, healthcare power of attorney, a directive. You'll see a document called the 5 wishes. That's the same thing. It's basically a document that has 2 parts. Some attorneys will do it as 2 separate documents. I do it as one document just to make it easy. But it's one part's the living will part, which is simply the scenario where you're designating to the world or to your doctors that if you're in a scenario where machines are keeping you alive, there's really no hope of you recovering. Some people might think of that as a comatose scenario, although, you know, there could be a medical reason why that might not be applicable in that scenario. But if you're in that state, you're telling the world, I don't want to be kept alive any longer, just let me go. And perhaps, you know, give me medicine and food to make sure I don't feel pain or something like that. But that's essentially what that part of the document addresses. And if you want to change the terms of that to make it fit with what you want, then that can be done. But it's essentially you saying that that's what you want done. It's not authorizing someone to make that decision for you. It's you saying, I want that done for me. Now, the other part of the document is more traditional healthcare decision-making, healthcare power of attorney, if you will. And that's where you are authorizing an agent, you're naming someone to make medical decisions for you if you get to a point where you can't do it yourself. Now, in my document and in the state of Virginia, and in a lot of states, it's usually determined by two doctors or a doctor and a psychologist. They will make a medical determination as to whether you are competent enough to make your own medical decisions. And if they feel that that's not the case, then they will certify that. And then at that point, your agent takes over and makes whatever decisions you've authorized them to make. Now, how many agents do you have? You can name as many as you want, 1 or 2 or 3, whatever. I probably wouldn't go beyond 2 or 3, because then you get into a problem where, you know, well, who makes the decision and what happens if some people disagree and that kind of thing.
Did you make appointment, George?
But,
Did you get appointment?
you know, when that happens, you need
Huh? Oh,
to, here, someone is, I'm not sure if someone needs to go on mute or not. So, anyway, the agent, normally, once they've been certified that they can act pretty much whatever you could do
huh?
if you were
Yep.
incompetent. So, or if you were competent. So they have carte blanche authority to make all medical decisions, hire
Sorry, Jared.
doctors.
Debbie, will you please mute?
Yes.
If
Thank you.
everybody can please
Sorry,
mute,
Jared.
that would be great.
Oh, that's okay. Anyway, so what I was saying is the agent can make pretty much whatever decisions you could make, hire and fire doctors, deal with your drugs, your food, put you in a facility, take you out of a facility, do a DNR, whatever. I mean, it's really whatever authority your document has provided for your agent. When I do a document, again, like the regular power of attorney, I make it as broad as I can so that your agent can make whatever decisions you could make. Because we figure, you know, you would want to have your agent make whatever decisions were appropriate for your care. So what happens if you don't have an advanced medical directive? In Virginia, different states have different rules. In Virginia, as far as the medical decision-making component is concerned, they do have a hierarchy in the statute that kind of walks through, you know, categories of people of who would have authority to make decisions. Like for, I believe offhand, it's like your spouse would have the first level of authority. Then after that, it'd be your children, then maybe your parents, and then it maybe goes to siblings or something like that. But the point is that you don't have control over it. It's whatever the state law says. And so you need to consider that when you want to make or when you decide who you want to name as your agent. And as far as just to go back to the power of attorney, if you don't have a power of attorney, what happens then? Well, nothing happens then. And really the only alternative from a practical standpoint would be to have someone appointed your guardian. And that's an actual legal proceeding that takes a couple months at minimum from start to finish to have someone legally appointed your guardian or conservator who would have authority over bank accounts and financial decisions. But during that time, no one's making decisions for you and things can happen. Especially if health-wise the person has gone downhill and you have no control over what they can do. Now, trusts. Trusts are done a lot of times nowadays. We do them all the time. That's pretty much our bread and butter. They're not one of the 3 documents that I had stated earlier. And that's because a lot of times some people just don't do trusts. It's not, you know, some people hear about them. They'll certainly see them, you know, online, Google them, and see them talked about on TV sometimes. There's lots of different trusts for different things. So in the estate planning context, the typical run-of-the-mill estate planning context, you typically have what are called living trusts, revocable living trusts. You'll also see sometimes some trusts called irrevocable trusts, and I'll talk about those in a second. But those are the 2 primary types of trusts that are done in estate planning. There are tax issues you need to consider when doing a trust. They're not complicated tax issues, but, and certainly nowadays with the changes in the tax laws over the last 10 to 15 years, they aren't as prevalent as they used to be, but they are still there, and it's important to consider when you're thinking about whether to do a trust or not. A revocable trust, the best way to describe what a revocable living trust is it's basically a will substitute. It essentially takes the place of your will in that it will say, when I die, do this with my estate. Give it to this person, give it to that person, my spouse, my kids, you know, whatever. It does that. It also has provisions, and this is why they call them living trusts, as to what to do while you're alive. And that's why they call it living trust. The main advantage behind a living trust, a revocable living trust, the most prevalent advantage is it minimizes the risk of probate. And I'll talk about what probate is in a second. We generally want to try to avoid probate if we can. Now, it also provides a way to administer your affairs while you're alive if something were to happen to you where it was more difficult or just not possible for you to handle your affairs on a long-term basis. For whatever reason, the most common, you know, you get Alzheimer's or you've had a stroke, dementia, you've just simply gotten so old that you just can't handle things anymore. It's much easier for someone to handle your affairs through a trust than just through a straight up power of attorney. Now, that's not to say that a power of attorney is not important. It is important, and it's good to use those, and you should have those because there's some instances where you need to use a power of attorney that a trust doesn't apply to. But I've found, particularly with banks and other financial institutions, they tend to be more trust friendly than just with straight up powers of attorney. I don't know why, it's just how it is. But that provides a way to handle things for you while you're still alive. Another advantage to a will or to a trust is it's a private document. You can put whatever family dirty laundry is in your family in that trust, and it will not become public knowledge. You put it in a will, it may become public knowledge because a will, if you have to probate it, when you probate it, it becomes a public document, just like a deed. And anybody can go to a courthouse and look up that will and see what's going on in your estate. So some people don't want to do that. A trust is also easier to change if you want to change it while you're still alive. You can change a will. The problem with changing a will, though, is that because a will has certain signing requirements and witness requirements, a lot of times if you want to change your will, you got to get all the witnesses back together, not the same witnesses, but you got to get two witnesses and a notary all together at the same time in the same place. That gets to be kind of a pain, especially if you want to just make a very minor change. A trust doesn't need all of that. A trust just needs a notary usually. And so that makes it a lot easier to change on the fly if it's a very minor change, or if for some reason it's a very time sensitive change and you need to get it done quickly, that makes it difficult for you to get witnesses all together. Now, there are some disadvantages to doing a living trust. Usually the disadvantages are in the front end after you've signed the trust. You do need to have a little bit more financial proactive awareness. And that tends to be because with a trust, a lot of its advantages depend on your assets being titled in the trust at some point. It doesn't have to necessarily be right after you've executed the trust, but it does need to be at least addressed before you've passed away. Obviously, no one knows when they're going to pass away, so it creates this issue where you need to have at least some financial awareness about what's going on with your estate prior to your death. You need to at least look at your assets to see how they're titled and see if they need to be changed or not. Some assets should normally be retitled into your trust. Some shouldn't be retitled into your trust for other reasons. And so you just need to take time to look at that. And so it gets a little bit more involved. So some people just don't want to deal with it. They're like, look, I just want a will. I just want to leave it to my spouse or to my kids, and I don't care. Just let them deal with it. Okay, that's fine. I just tell the client, that's fine. We can do that, but they're going to have to do a lot of legwork then when you pass away. Some are okay with that. Some then that convinces them that, well, I don't want them to have to deal with a lot of headache, so let's just do it. So you just have to be aware of that when doing a trust. You also want to make sure that the attorney doing the trust understands trusts. Some attorneys are knowledgeable enough with trusts that it's not a big deal to them. Some attorneys may think they're knowledgeable about trusts, and maybe they don't know about trusts. That's hard to determine. Some attorneys, though, will be upfront enough to know, look, I don't know enough about trusts. Wills, I can do wills, but trusts, you need to go get an expert who knows what they're doing. So you just have to feel that out when talking to an attorney. One thing to bear in mind with a living trust, because this gets asked quite frequently for other reasons, these types of trusts, irrevocable living trusts, they do not offer any liability protection from creditors. So some people will say, is this going to help protect me from the nursing home taking my house? That's like the big one that we always hear. Or can I still qualify for Medicaid? These kinds of trusts do not give you any protection whatsoever from those kinds of issues. So in other words, if you have all of your assets in a revocable living trust, you will still have to satisfy the same rules for Medicaid qualification that everybody else will. It doesn't give you any advantage in that. They're still your assets. They're still considered an available resource. And so it doesn't give you any advantage in that realm. There are trusts that do that. There are advantages and disadvantages to those kinds of trusts, but those kinds of trusts normally require a lot of advanced planning. And so they're a lot more difficult to deal with. But that's not what these kinds of trusts are. An irrevocable trust is basically what the name is. It's irrevocable, meaning that it's not intended to be changed once it's signed. Now, historically, irrevocable trusts used to be very ironclad. You were not getting that thing changed under most any circumstance. Nowadays, that's not really the case. There are procedures that can be employed to change an irrevocable trust. Virginia has a statute called the Uniform Trust Code that walks through instances where an irrevocable trust can be changed. So that's not quite the case as it historically used to be. Now, common uses for irrevocable trusts are creditor protection, like what I was saying with the Medicaid. That's a type of an irrevocable trust. Special needs trusts for, if someone has a special needs child or a special needs parent, there are trusts that can be set up for them that are intended to be irrevocable trusts. Life insurance trusts, those are now starting to kind of come out of favor. They used to be used primarily to hold life insurance policies so that when someone died, the insurance was out of someone's estate and the proceeds would go into a trust that could then be used for that decedent's beneficiaries or to pay off creditors or estate taxes. Nowadays, they're not as necessary just because the estate tax limits have gone much higher. So it's not as necessary to have insurance anymore to help pay the estate tax. But they are still around, but they are usually irrevocable trusts. And then a revocable trust will automatically become an irrevocable trust when the person passes away. And that happens usually automatically, or if they become incapacitated, usually by the terms of the trust. So not every revocable trust stays revocable throughout. Once the person dies, then they become irrevocable, and that's like a will. And that again, that goes back to its basic intent was it's a will substitute. Other assets that you need to think about when you're doing estate planning are, these are some of these assets. Real estate, you need to think about how it's owned. Joint ownership, usually, spouses will own their residence together. You got to look at the titling on the deed to see whether it's joint with right of survivorship or something called tenants by the entirety. Virginia has the tenants by the entirety statute, but West Virginia, for example, does not. Some states have it, some states don't. Essentially, the distinction is that a tenants by the entirety is like joint with right of survivorship, except it's devoted exclusively to married couples, and it provides additional creditor protection to the married couple. Other than that, it's pretty much the same as a joint with right of survivorship. Another way of owning real estate, sometimes with estate planning, is something called a life estate remainder. You'll see this a lot of times with kids and parents. It used to be much more common maybe 30 to 40 years ago. You'll see it still to some extent nowadays for other reasons, but essentially what it involves is where a parent, for example, will gift a partial interest in their house. The remainder interest is what it's called, to their child or children, and retain what's called a life estate. And what that gives them, it gives the parent the right to remain in the house for the rest of their life, and they retain complete use of the property, and no one else can use the property except for them up until the point in which they die. And then when they die, the title automatically passes to their kids as the remainder interest, or whoever they named as the remainder beneficiary. It was essentially a quick way of designating a beneficiary for the house or for other real estate. The problem they ran into, though, was if mom or dad needed to sell the house, the kids had to agree to it because they were a partial owner in the home. In addition, if they sold the house, the kids also got part of the proceeds because they were the remainder beneficiary and owned a partial interest in the house. So mom and dad didn't like that a lot of times. And so, or it maybe created a problem for other reasons, just with the disposition of the funds. So Virginia created something called a transfer on death deed not too long ago, which is more of a actual beneficiary designation where you can name a beneficiary of a piece of real estate. And that is a pure beneficiary designation where the mom or dad, in this case, retain total ownership over the property, and they can change their mind at any time on the beneficiary or take off the beneficiary. But it does provide an automatic transfer upon death where when mom or dad pass away, the title transfers automatically to the kids or to whoever you've named as a beneficiary. Trusts and limited liability companies are used quite often nowadays with real estate, where you'll transfer title to real estate into a trust or to a limited liability company. The limited liability companies are usually used with if it's an investment property or rental real estate of some sort. Trusts are typically used when it's your own personal residence or maybe a family home where you're not concerned about liability so much. Other assets, a closely held business. If you have your own business, or someone in your family or someone else has their own business where you need to deal with how is it going to pass following your death? Is it going to go to your spouse? Is it going to go to your kids? Do you need to sell it? Do you need to pass it to like a close employee or longtime employee who will take over the business? Those kinds of issues need to be thought out and addressed through your documents or through the business documents, ownership documents themselves. Retirement accounts, 401ks, IRAs, 403bs, 457s, all of those kinds of retirement accounts need to be addressed. Particularly nowadays, they just passed a law at the beginning of 2020, or took effect at the beginning of 2020, concerning beneficiaries of these accounts and how they're taken out following your death. The main point is that with the exception of spouses and children and disabled individuals, any beneficiary receiving those accounts pretty much has to take that money out within 10 years after they've inherited it and pay the tax. There might be other exceptions, but those are the big exceptions, is your spouse or your children. And with respect to children who aren't disabled, they have the 10-year period starts once they become an adult. So it totally changes the estate planning of those assets from what they used to be. It used to be that if you were a child and inherited a 401k or IRA or any of those other retirement accounts, you could start taking the minimum distribution, but it would be taken out over your life expectancy. And so if you were, in your 30s or 40s and inherited those, you didn't have to take that money out, or you could take out a very small amount over a much longer period of time, which really reduced the amount of tax you had to pay. Now you have 10 years and you got to pay the tax, and there's really no way around it. Now people are trying to think about ways to get around it and do different planning approaches, but it's very new, and so people haven't really flushed those planning opportunities out yet. Special collections, I usually tell clients, if you've got some sort of unique collection that might need to be appraised by an expert, it helps to let people know who those experts might be. I, for example, had one client who had a very expensive glass collection that they wanted certain people to do the appraisals on, and they wanted those people because they knew they were experts in that area and would appraise it appropriately. Otherwise, your kids or loved ones may not know who to pick, and they may just pick someone who may not really know what they're doing and may not give them a good appraisal on it. So it's just something to bear in mind. Other personal property and automobiles, you just have to think about if there's certain things you want to give to certain people. Virginia allows you to make a list for personal property. If there's certain things you want certain people to get, you can do up a little list, handwritten list, typed up list, doesn't really matter, and just keep it with your documents, and that'll work. That'll be sufficient for them, for your executor to use, as long as your will denotes that. Automobiles, some people will say, well, do I put my automobile in my trust? You can do it. I wouldn't normally recommend it, just because the DMV makes it very difficult to deal with those once they're in a trust. The Department of Motor Vehicles does have a way to name a beneficiary of an automobile. There is a form. The only restriction is it has to be an actual person. You can't name a trust or an LLC or a corporation or whatever the beneficiary of an automobile. It has to be a person. And then if you've got property located in other states, like real estate, it's very important to plan for that. Usually the easiest way to deal with that is put it in a trust, because if you don't do that, then you may have to probate in another state. And there are procedures to do that, but it is kind of a pain. So what is probate? Probate is generally the process where the court gets involved to make sure that your executor does their job. They make sure that the executor doesn't skip town with all of your money and the beneficiaries don't get anything. And so what they do is they make the executor file paperwork periodically to list what's in your estate, the value of it, and then they generally have to report whatever income and expenses have been received and paid out, so that there's a full accounting of what has happened during the course of the administration. Well, the advantage of that is there's complete transparency to the beneficiaries as to what's going on. The problem with it is a pain to do for the executor a lot of times, particularly if your estate is sizable, or if your estate is not sizable and everybody's very close, like it's a very close nuclear family where everybody gets along, and you don't need to have all of that transparency because everybody talks already. It's overkill. So there's ways to avoid probate, and it all involves titling. Your most classic example is joint ownership with survivorship, tenants by the entirety. That all passes automatically by operation of law. And so you don't have to probate the asset. That's why a lot of times when the first spouse passes away, a lot of times the surviving spouse doesn't have to do hardly anything. It's because most of the time they owned everything jointly with their spouse, so it automatically passed. When the surviving spouse passes away, though, that's where a lot of the difficulty may arise, is because no new joint owner was named with a kid, or they didn't name a beneficiary or do a trust, and that's where the problem becomes. Trusts will avoid probate, but again, that depends on whether the titling has been addressed, where you've named the trust as the owner or the beneficiary. You've done beneficiary designations, like I mentioned earlier with the insurance. It automatically goes to the beneficiary. And then if you've made any lifetime gifts, gifting the remainder interest, like I talked about earlier, of the piece of property to your kids, that's a gift that will automatically avoid probate. So there's different ways to avoid it, and again, there's advantages and disadvantages to doing that. These are items that I would watch out for when doing estate planning. Online software. Now, I'm somewhat biased since I'm competing with online software, but I'll be honest with you, most of the time when I've seen people bring in a will or a document that they've done with through an online software, the problem with it is it's too overly generalized. Some of them will try to make it state specific, but again, there's no substitute for a professional. It's just like going to a doctor. You could go to WebMD and, RX, prescription stuff online, but it's not the same as actually going to a doctor and talking to them. A lot of these issues with estate planning, they're governed by state law. And each state has little tweaks to their law. Some states are very different than other states. Like you have some states that are called community property states, where ownership between spouses is very, very different than what are called separate property states. Virginia is a separate property state, and basically it means that each spouse can own their own property independent of the other spouse, that you do not have a unilateral right to the other spouse's property simply by virtue of being married to them. Community property states are basically the exact opposite. If there's no document, no will, then your state law will govern what happens. And so I was saying earlier, if you have no power of attorney, your only option is really a state guardianship proceeding to allow someone to come in and take over the bank account. If you have no will, that's what is called intestacy, and state law governs where your estate goes. It basically goes to your spouse, then your kids, then your parents, then your siblings, and it finds its way down the family tree until it hits someone. It doesn't go to the state, unless you pretty much have nobody. It would be very difficult for it to be as cheated, that's what it's called, to your state, but that could theoretically happen. The usual big problem is when there's mixed marriages nowadays. A lot of marriages are second marriages where you got kids from other marriages and maybe half siblings and things like that. That may totally change where a mom or dad's estate goes based on state law. I talked about the new retirement account rules for 2020. Some practitioners, I'll see practitioners or clients who come in that they got these massive 3-ring binders that are 2 or 3 inches thick. And usually those binders, what they are, they're all your estate planning documents, but they're designed to basically address every conceivable scenario that anyone could encounter. And the problem is no one size fits all with estate planning. At least that's my opinion. Everybody's family is unique. Everybody's situation is unique. Family situations are very dynamic nowadays. Like I said, with second marriages and kids coming in from different marriages, So it's very important that your estate plan address your scenario so that you understand it and it addresses it the way it should be. Powers of attorney, you need to make sure that the powers of attorney are addressing your scenario, and make sure you've got funeral decisions made. Some funeral decision or funeral homes will have someone designate that, or have you designate someone who can make whatever decisions weren't made in case there's a question. But sometimes those designations may be someone different than who you've named in your power of attorney or your will. And so you got to make sure that everything coordinates together so that it's who you want it to be, or the people that you want it to be. That's pretty much all I got. There was a lot there, but that's the basics, I guess, of estate planning. I'm perfectly willing to answer whatever questions anyone may have, so I'll open it up to the floor.
One question is if a beneficiary, if someone is named the beneficiary and they receive their, I hear somebody talking, but anyway,
Hello?
does the beneficiary have to use their money that they
Hello?
receive to pay for all the funeral costs?
Well, the technical answer would be no. And the reason is that it depends on who the beneficiary is. If the
Oh, we're just having a
beneficiary,
Zoom call meeting
if the
on
beneficiary is,
beneficiaries, and they can't hear me.
oh,
Beneficiaries
Yeah,
do people need me to
and
repeat the question?
Susan, we
Estate.
can hear you.
estate planning.
Hello, Susan.
It's actually there's a lot of good information.
Hey, Jared, can you hover over where it says when you see it moving, if somebody's talking and it's not who is actually talking to you, you can mute them if they can't hear us.
Okay, yeah, there's just a lot of people. I can't, let me go up
There's a
to
lot of people.
the grid video here, grid, so I can see
I
here.
apologize for interrupting.
Oh, that's okay. The question was, if someone gets an insurance payout, basically, are they required to use that money to pay for funeral expenses? And the technical answer is no. And the reason for that is because it depends on who the beneficiary is. If you've got a beneficiary that is the estate, for example, then that answer would be yes. And the reason being is that your estate, your executor is obligated to pay your debts and funeral expenses. So in that instance, that would be true. But most of the time, I would say the vast majority of the time, your estate's not the beneficiary, it's someone else. It's your kids, your spouse, it's an individual. Because that individual has inherited that money, that is their money. They can do whatever they want with that money. If they want to use it to pay for the funeral expenses out of the goodness of their heart, they can certainly do that. But there is no legal requirement that that person use that money for anything related to the estate. I have seen it where the person may name the funeral home the beneficiary for that very purpose. So they want that particular insurance policy to be used to pay for the funeral costs. But I would say the vast majority is they name their kids or their spouse the beneficiary. And you know, the best example, you know, they name, let's say they have 3 kids and they name the 3 kids the beneficiaries. So the proceeds are split 3 ways. Not all 3 of them have to use it. One of them could say, I need that money. I need it to pay credit card bills. I need to pay this, that, the other thing. So no, I'm not paying funeral costs. There's nothing you can do to make that person change their mind. So and that goes with any sort of joint or beneficiary asset. It's like I said earlier, it passes outside of the will. So if it's a joint asset that you own with someone else, they will automatically inherit that asset upon their death. And then that's their asset. They can do whatever they want with it. Same thing with the beneficiary. There could be an exception if it's a joint asset that is secured by a liability. For example, house that has a mortgage on it. If you have a piece of property that is mortgaged and you bequeath that property to someone else, that property typically, the question will be, well, who pays the mortgage off? Under Virginia law, and there was a Virginia Supreme Court case that had to address this issue, that the real estate will normally go not subject to the mortgage, and the estate has to pay that mortgage off unless the will has said that property goes subject to the mortgage. So if someone wants to inherit a piece of property under a will, you need to think about, well, what's going to happen to the mortgage? If it's a joint property, like with your spouse, where there's already a joint owner on the mortgage, that doesn't really change the scenario, because then if your spouse is on the title and they're on the mortgage, they're going to still be responsible for the property. If the spouse is not on the mortgage, but they inherit the property, then the bank can call the loan due and arguably take the property back. Now, I think in reality, what ends up happening, they work with the spouse to try to get the spouse on the mortgage and just transfer it over to them. But I guess you could have a scenario where if the spouse can't make the payments because they don't have the financial ability to make the payments, or their credit, isn't sufficient, or they have to refinance the loan, you could have a problem there.
There's another question. It says, if you have an estranged child from the family, do you need to say in the will that they are left out?
It depends on what you say in the will. If you say, I give all my property to my children, then yes, you need to say that they are left out. Otherwise, if they are a blood child, lineal, biological child, they will inherit. If you say, I want to leave it to my children, but you want to exclude them, then you need to say something. However, I specifically exclude my child so-and-so from the provisions of this last will and testament. Or another way you could say it is, however, for all purposes under this will, my child so-and-so shall be treated as having predeceased me. Something like that. There's different ways you can do it. But like, for example, you need to think about, well, if your child's estranged, do you want their children to get anything? If they have children, your grandchildren, or not. So there's different, you have to think about that. The second scenario I gave there, that where you're saying my child shall be treated as having predeceased me.
You want some oatmeal?
That will be looked upon as you've told them they're predeceasing you, but now it's going to their children. So let's say you have a child who's horrible with money, but you really want to benefit the grandchildren. That's how you would do it. Or you'd say, you name the grandchildren specifically, or you say, my son so-and-so shall be treated as having predeceased me, period. And it'll then go automatically to the grandchildren. So there's different ways the language can be worded, but if you want to exclude someone, I always tell someone, then you need to specifically exclude them just to avoid any confusion.
Thank you. I'm looking to see if there's any other questions. I don't see any in the chat. Is there? Oh, Janine put in here. There are a few. Okay, so here's one. What if you have property in a foreign country?
Ooh, that's a good one. I've dealt with property in foreign countries before. Usually I will tell the person, well, I guess first it depends on what kind of property we're talking about. If we're talking about real estate, I usually will tell the people they need to get an attorney over in the country, because it's going to depend exclusively on that country's laws. Primarily because a lot of countries have very specific laws about who can own property in their country. They may say that person needs to be a citizen of the country. If it's in an entity, some countries they don't recognize LLCs, for example. They'll have corporations, or they may have very specific rules about trusts. And so you really need to have an attorney over in that country who knows what they're doing, address that. If it's something like a bank account or some other financial asset, you still should get an attorney over there, but then there might also be other rules, tax rules specific to that country. The U.S. has tax treaties with various countries, which will dictate how those types of assets might be taxed in the U.S. versus the other country, which may be different than the basic U.S. tax law. It will depend on whether the person who lives here, whether they're a citizen or not. I just got done addressing a scenario where the person, she was a U.S. citizen, but she had inherited an estate from her mother, who was from Uruguay. And her mother was an Uruguay citizen, not a U.S. citizen, and didn't live in the U.S. But she had money and she had inherited it. And so we had to look up what happens. How does that get dealt with? And there's weird rules. There was no tax treaty with Uruguay, with the U.S., so there was different rules pertaining to that. So just as much as there might be estate planning issues, there could also be tax planning issues that need to be addressed as well for international property.
That is good to know. So I guess the bottom line is definitely reach out to you, somebody that can guide them through those things.
Yeah, well, and particularly if it's international stuff, a CPA might have, if it's a bigger CPA firm that has experience in international tax planning, they might also be a good resource to reach out to.
Okay. There's one other question. Are there some estates that are too small to be handled by an attorney? For example, they just have a house and a car, no other real assets to speak of.
I am somewhat biased in this. I'd say no, but it usually, it's not that they're so small. The value isn't the problem. It's the handling of it after the person has passed away that creates the problem, or can create the problem. I would say 9 times out of 10, there is more trouble with smaller estates than there is with bigger estates, or perhaps maybe not so much bigger problems, just different problems. Most of the problems that you encounter with the big estates, it's just because of the money that's involved, the size of the estate, or it's the family dynamics because everybody wants their share. The problems that you run into with the small estates is it's almost always family dynamics. It's people who, they want that particular item in the house because mom wanted me to have that. And even though the value of that particular item might be next to nothing, it's somehow intrinsically valuable to that person, that child, or that loved one. And so they've assigned a lot of emotional attachment to that item. And because of that, the planning needs to address that so that there are no questions afterwards about, well, who's supposed to get that? Well, mom told me I was supposed to get that. Well, when did that happen? Oh, she told me right before. It just creates a lot of headache. And so more headache, I find, comes from those scenarios where the estates are small, where people are fighting over the emotional attachment of the item rather than the value of the item. And the emotional attachment is a lot more powerful and it can be a lot more troubling to the family overall, because you can break up families over stuff like that. I've seen it happen. I've seen it where families get into the administration and it irreparably damages their relationship, where they don't speak to one another after the administration is over because of all the stuff that happens afterwards. And it's troubling. So I would say it doesn't really matter what the value of the estate is, as it is just managing what do mom or dad want done. Because more times than not, if mom or dad have put it down on paper, the kids will listen because it was mom or dad. Even though they may not like it, they can accept that because it was mom or dad. And that's all you can do.
I can, very quickly, I can attest to that because my dad didn't have very much worldly possessions, but I was left the one, everything was in writing, and it made things so much easier. You know, it freed me to not have to worry about things. So I would definitely answer that just from personal knowledge that yes, I would say do it. It made things a lot easier. There's another question. How often would you, should a will be revised?
There's different opinions on that. I mean, my personal feeling is it kind of depends on where the client is in their stage of life. So for example, a younger client, you know, young family, got a couple kids, but they're real young kids, maybe they probably don't have to look at their will for 10 or 15 years, maybe once the kids start going off to college, because, you know, nothing's really changing with the family dynamic so much. The kids are still the kids, mom or dad are still in charge. Their estate may be changing, but it's not changing as to what needs to be done with it. It's usually almost always going to the spouse, or if not to the kids, and someone's watching over it for the kids' benefit ultimately. Once the kids start going off to school, then maybe things are changing, at least with the parents, because obviously they're older at that point. Perhaps health is starting to creep in as a factor for some people because, you know, they're in their mid to late 40s, early 50s by that point. So maybe they need to think about where their health is and whether that factors into how often they look at it. Once the kids are out of school and the parents are kind of in their, I would say, upper 50s, low 60s, I tend to tell people maybe every 5 to 6 years or so. If they're looking at it, think about what happens if you were to die in the next 5 years. Is it worded that you could feel comfortable with where things are going if you were to go in the next 5 years? And then maybe look at it again in 5 years. If nothing changes, then nothing changes. But it kind of gets you into thinking about that. And usually by that point, health-wise, things may be changing in about every 5 years or so. So that probably gives you a good frame of reference.
Okay, that is really good information. We are at 10:11 right now. And if there's not any more, I can't see any more questions in the chat. Jared, if you don't mind to send me all of your information, I will get it out. We'll make sure that we get it out. The recording's going to be where the agents can see it, but we can also get your information out to them. So
Okay.
that way, if they have further questions or would like to talk to you for themselves personally.
Sounds good to me.
Okay, well, without any other questions, if there isn't any, speaking for the whole company, I want to say thank you. Actually, let me I had to come out to the car. So speaking for the whole company, I want to say thank you very much. This was great information, and we look forward to hearing from you soon.
I appreciate it. Thanks again for having me.
Thank you. Bye, everybody.